So hello everyone, my name is Alex Radford. I'm a lawyer, English lawyer and Spanish lawyer with my law in Spain. And today joining me is, hello Penny, how are you?
Hi, I'm very well, thank you.
Okay, so Penny, thank you ever so much for joining us today. And I just like, I'd like you just to introduce yourself and just tell everyone about what is it you actually do.
Right, well, I'm a specialist family lawyer specializing in more complicated or higher net worth divorces. And we act a lot of the time for people who are expatriates or who have property outside the jurisdiction of England and Wales. So we're very, very aware of the sort of problems that people like your clients have.
Okay, excellent. So Penny, we act for a lot of international clients buying, selling, and inheriting property here. And when someone's considering buying a Spanish property, there are various ownership options, and we go through those with the clients. And one of them, if they're moving to Spain, then I'd always say buy the property in your own names. However, if you are buying a Spanish property as a holiday home, then obviously you can buy that in your own names. You can own it 100%. But there is also the option of, for example, mum and dad buying a Spanish property. They hold a life interest in the property. So they buy the property 50-50, have a life interest in that. And then any children that they've got aged 18 plus could hold the legal title. So that basically, works quite efficiently from a Spanish inheritance tax point of view, because when they pass on, there's no inheritance tax, and the children would automatically inherit their life interest. So it's efficient from a Spanish inheritance tax point of view, and also actually from a UK inheritance tax point of view, because if the parents live for more than 7 years, then it could be considered a potentially exempt transfer, and there's no inheritance tax in the UK. So it could be a win-win for someone considering buying a property in Spain. However, Penny, and this is where you come in. So we've got, mum and dad are going to buy this property, and they've got two adult sons, and one of them is married, and one of them is thinking of getting married. What advice would you give to the parents, because they want to ensure that their sons actually inherit the property?
Right, okay. Let's start from the beginning. Before we go into the question of prenuptial agreements or postnuptial agreements, let's talk about the basic law. The basic law is that assets that are acquired from outside the effort of either or both parties during the course of the marriage are not matrimonial assets in the first instance. So the basic law that you'd be looking at equal division as a starting point doesn't apply to those. So that's the first thing to consider. The second thing to consider is the second part of the basic requirements under Section 25 of the Matrimonial Causes Act, which is that you have to look at the needs of the parties. So if the needs of the parties are such that 50-50 of what was acquired during the marriage isn't going to be enough to fulfill basic needs like accommodation or whatever, then you will look at the other assets outside. And that's when this asset or other assets that have been acquired through family or in other ways or brought into the marriage might come into it. So what can you do about that? Well, you can have what is called a prenup, which is a prenuptial agreement, which is what it says on the can. It's an agreement you make before you get married. Or you can have a postnup agreement, which is a postnuptial agreement made after you get married. Now, I'm sure I don't need to spell out the difficulties in getting somebody to agree to an agreement after you've got married, because that is always going to be a difficult one. That's not to do with how enforceable it is, it's whether or not your partner will agree to it. And I can tell you that in most cases, when they take advice from a lawyer, because they must have separate advice from a lawyer, they're going to say, don't be ridiculous, don't sign anything. Okay?
Yeah. So although Penny, most famously, recently, I understand that Melania Trump has signed a new postnuptial agreement with Mr. Trump.
That's not quite how I heard it. What I heard that she had renegotiated her previous contract. So I think she's up the ante.
Right.
I don't think it's that way. I don't think it's that way around.
Okay,
Bear
okay,
in
interesting.
mind, he wants her support at the moment, doesn't he? Yeah.
Yeah.
So
So,
I think, you know,
but yeah,
renegotiation can work both ways. Okay.
but you're right. A post-nuptial agreement is going to be more difficult, especially if you're in a happy relationship, and also your parents are going to buy a property in Spain and say, "Oh, do you mind, just in case my parents want us to sign an agreement, just in case we do get divorced, or heaven forbid, have you ever thought of us getting divorced? Well, you never know what happens. Well, so it could cause all sorts of issues,
Exactly.
and arise. It can bring up issues that might never have risen before. So all of a sudden, yeah, it may be difficult to obtain that, but not impossible.
No,
Especially if
and
there's
it might be that you might approach it in a slightly different way, which is what I would advise, which would be that the request for the postnuptial agreement should come from the parents' lawyers, not from the husband. Okay.
yes, yeah,
Say this is what we've been advised by our tax, etc. lawyer, and will you agree with this? Obviously, this is an advantage of us all being able to use this holiday home, etc., etc. That would be the way to approach it in a practical sense. Okay.
absolutely. I agree. Definitely best to come from
Yeah,
the parents' lawyers.
absolutely.
Yeah,
That would be the best way. But let me just talk about the enforceability of prenuptial agreements. Prenuptial agreements, first and foremost, are not recognised by statute in England and Wales. You can't absolutely guarantee that a prenuptial agreement is going to work, okay? But in 2010, we had a case which was an absolute watershed for these sort of agreements, which was called Radmacher and Granatino. And in that case, the court did recognise not all, but most of a prenuptial agreement for the first time and gave some indications as to what you had to do. Now, we've recently had another case, which is as recent as 2023, which is called MN and AN, very memorable, obviously. And in that case, the judge went a bit further. But there are certain things to bear in mind when you have any sort of prenuptial agreement. The first one is the overriding principle in family law in England and Wales, which is that it's got to be fair. Okay. Now, it seems to me that the idea of parents giving something which is a gift to their child, which in fact the family will have use of, etc., etc., and they want that to be excluded from a divorce, that seems fair. That seems reasonable. So that's where you start from. Okay.
that's a good starting point.
Yeah, that's a good starting point. The other thing you're going to have, which is going to be very important, is you're going to have some sort of financial disclosure each way. You'd be surprised how many husbands and wives don't know what their partners have got, okay? And that happens quite extraordinarily frequently, particularly in families who have more than the average, okay?
Right. Yeah.
And in fact, sometimes there is a great deal of reluctance to reveal assets. That will cause a problem if you try to enforce a prenuptial agreement later, okay? If there isn't at least a basic idea, and that basic idea must be accurate, okay? The next thing is that both sides must have at least the opportunity to be legally advised. Now, that can be a problem if you've got one party who actually doesn't have many resources and the other one's got all the money or all control of the money. They can't both be represented by the same solicitor because there's a clear conflict. They each have to have some representation, some advice separately on the possibility of this prenuptial agreement. Okay?
Yeah.
And then the final one is that the court always has the ability to have a look at the prenuptial agreement and see if it was fair. And that will look at all the different factors. And the big ones, as I've just mentioned before, are whether or not it fulfills all the needs, and not just of the parties, but also the children, okay? So they'll look at all those things, and if that looks as if it was reasonable in the first place, then you're going to be more than likely to have some success. Not complete success. They might say some of it's valid and some of it isn't, but you're likely to have some success. And that is very good, because the one thing you must always remember about prenuptial agreements or postnuptial agreements is that if you haven't got one, it won't work.
Yeah. So Penny, it's better to have one than not to have one.
Oh, yes, yes.
Yeah. Yeah. Okay, that's good. Right. So in effect, and how would you approach this? Again, would you the same as the post-nup? Would you say, our parents, so my parents' lawyers are recommending this prenuptial agreement, and we would recommend that you seek independent legal advice as well?
Yes. And I think I would approach it on the basis that my parents want this as a comfort to them to know that their child is going to benefit. We're not trying to say that there's going to be a split up. We're just trying to say that this would be fair. It doesn't affect any of the other assets we've got. It's just the share of this. Okay.
Yeah, yeah. Because the alternative, Penny, would be that basically, so we're talking about mum and dad having a life interest in the property, and the children receive the legal interest. Okay, but the alternative would be mum and dad buy the property in their own names, and basically then put in place a Spanish will for the Spanish asset and leave it to their child. Now, in that case, would you recommend a prenup as well?
Yes.
Yeah.
I still would recommend the prenup. I think
Yeah, so
anyway, because actually one of the difficulties you've got is the relationship in probate law between Spanish law and English law.
Yeah.
Now, in English law, the fact of the matter is that a will isn't a legal document as such until somebody dies.
Yeah.
Okay, so the fact that somebody might have said they're going to leave you something in a will doesn't mean anything, because the day before they could leave it to Battersea Dogs Home.
Yeah.
Okay. I don't know whether that works like that in Spain, but it's how it works in the UK.
Yeah, I agree. I mean, it's only enforceable once someone dies. So, in effect, mum and dad leave as a surviving spouse. Typically we would put in place a Spanish will. They're quite straightforward, the Spanish wills. It would be, maybe depending on the 17 autonomous regions in Spain, each of them have their own inheritance tax laws. The Valencian community and, for example, the Andalusian community have changed their rules recently. So actually, from a tax point of view, it's quite advantageous for direct heirs to inherit Spanish property. So mum and dad going down to the children is maybe tax free. So in that case, we would probably recommend that you buy it in your own name, unless you want to go down the routes we talk about. But if they did do that, then yeah, we put in place a Spanish will, and you'll recommend, even though, so mum and dad die, the asset gets inherited by the child. This is like 10, 15 years later after they purchased the property, hopefully, and then all of a sudden the married couple are left with an asset in Spain that would be inherited by one of the spouses. And of course, the spouse, the other spouse, would be able to enjoy have the benefit of enjoyment of that Spanish property. But if they did get divorced, then the prenuptial agreement, so long as it's fair, would award the property would maintain the property in the ownership of the daughters, or the son of the daughter, or the heirs.
Yeah, the idea would be, actually, you'd have a more general clause than that. What you'd do is you'd say that assets acquired from outside the party's efforts, in other words, by inheritance or gift, etc., would not come into a division in the case of divorce. Yeah. But you'd have to put something in, of course, that this has to be seen in the light of Section 25 of the Matrimonial Causes Act. So let's just work out a practical example. Let's say you have a couple who've got, £800,000 net equity in property in the UK, and they get divorced. They can each have £400,000 for a house. Let's say they're both working and the children are provided for. In those circumstances, it is unlikely that there is going to be any claim, particularly if there's a prenup, okay? But let us say it's a more complicated situation. Let's say that actually there is a property which is only worth £200,000 net. and therefore when they separate, if they divide that, they're not going to have enough money to buy a house. There are 2 children. How are they going to manage? Okay. In those circumstances, the court is likely to say, well, there are children here. We're going to have to claw that back in terms of money's worth, not in terms of the ability to have the property, but in terms of disposing of the property and using that for accommodation, which is necessary because those are the needs of the parties. Do you see what I mean?
Yeah, exactly. So obviously you look at fairness as a parting shot, so to speak. But then the next point to bear in mind is, can they live on what they've got? Have they got sufficient means to bring up their children, etc.? Okay, interesting. Yeah.
And also, you know, elements like how long have they been married? You know, because although the starting point might be 50-50 after a short marriage, it's not likely to be 50-50 at the end of the day if one is much more successful than the other. Okay.
Yeah. So you mentioned that, but basically, if they inherited assets, that's not through their joint work and effort. Generally speaking, if in the UK, Penny, if a married couple do inherit assets, does that generally go to the spouse who inherits them? And is it considered their property, or would it be considered joint property?
Well, as I said at the beginning, the basic rule is that you exclude assets that were not acquired by either or both parties during the course of the marriage, including a period of cohabitation beforehand, so the whole relationship. It wasn't acquired by their efforts. So you exclude those when you start looking at the assets that are going to be divided. But if there are not enough assets to deal with basic needs, then the court will start looking at the resources that one party can call on outside the marital assets, and that would include such things as inherited property. Yeah,
okay, brilliant. Well, Penny, anything else to add? I think I've covered that. You know, for anyone who's thinking of buying Spanish property with their children, should certainly watch this video, and just if they've got any questions, come back to you, and just consider the prenup and postnup positions.
Absolutely, and I would be happy to advise anyone, and I'm sure that they should come to you in the first place, Alex.
Yeah, absolutely. Brilliant. Well, thank you ever so much indeed, Penny, for coming on today.
Thank you very much. See you again. Bye.
See you soon. Bye-bye.